Welcome to Module 5. At the end of this module, participants should be able to explain the concept and purpose of client due diligence, CDD, within the Nigerian legal profession, distinguish between standard CDD, simplified CDD, and enhanced due diligence, EDD. Identify transactions and legal services that trigger CDD obligations for lawyers. Apply the risk-based approach to client onboarding and ongoing monitoring. Understand documentation, record-keeping, and confidentiality obligations relating to CDD. Recognize the professional and disciplinary consequences of inadequate CDD. Client due diligence, CDD, refers to the set of measures undertaken by a legal practitioner to identify and verify the identity of a client, identify and verify the beneficial owner of a client or transaction, conduct effective source of funds and source of wealth inquiries, understand the purpose and intended nature of the business relationship, and assess and manage money laundering, terrorism financing, and proliferation financing risks. Within the Nigerian legal context, CDD is not a banking obligation. It is a professional responsibility anchored in ethical practice, risk management, and public interest. Lawyers' CCD obligations are captured under Part 3 of the Rules of Professional Conduct 2023, particularly at Rule 51, Section 5. The RPC establishes CDD as a mandatory component of legal practice. Rule 51, Section 5A require us to identify and verify the identity of clients, verify addresses, identify and verify beneficial owners, ascertain the true beneficiaries of the transaction, obtain an understanding of the source of funds, obtain an understanding of the source of wealth of the client. Rule 51, Section 5B require us to know the exact nature of the legal service being provided, understand how the work could unwittingly facilitate the movement or concealment of proceeds of crime, take necessary mitigating steps as provided in the rules. Rule 51, Section 5C require that if the practitioner lacks the requisite expertise to determine the nature of the work or identify MLTF risks, should seek expert assistance to ensure compliance, or decline the client instructions without prejudice. Rule 51, Section 5D require us to take steps to understand the commercial or personal rationale for the transaction. No obligation to objectively assess the rationale if it appears reasonable and genuine on the face of the instructions. Rule 51, Section 5E require us to exercise vigilance to identify and carefully review transaction aspects. Determine if there are reasonable grounds to suspect that funds are proceeds of criminal activity or related to terrorist financing. Document the review process. This documentation alone suffices to demonstrate compliance and assist in interpreting red flags or indicators. Rule 51, Section 5F require us to consider what action, if any, needs to be taken upon identifying risks or suspicions, and create an action plan to implement such action. This may include enhanced scrutiny, seeking more information, reporting where required, or terminating the retainer. Under Rule 51, Section 5G, the outcomes of the action plans, including the comprehensive risk assessment of a particular client or transaction, will dictate the level and nature of the evidence or documentation collated under a firm's CDD or EDD procedures. This includes evidence of the source of wealth or funds. Lawyers should apply proportionate measures. According to Rule 51, Section 5H, lawyers should adequately document and record all steps taken with regards to CDD. Robust internal records are also essential for demonstrating compliance during audits, regulatory reviews, or investigations. CDD obligations arise only when lawyers perform gatekeeper-triggering activities, not when they provide litigation services, courtroom advocacy, and pure legal advice unconnected to transactions. CDD-triggering legal services include property purchase or sale, company incorporation, trust or foundation services, and managing client funds. Drafting wills and litigation representation are not CDD required. There are three major types of client due diligence: standard client due diligence, simplified client due diligence, and enhanced due diligence. Standard client due diligence applies to most routine transactions and requires client identification, including name, address, and nationality, verification using reliable documents such as ID or CAC records, identification of beneficial ownership, and understanding the nature of the transaction. Simplified client due diligence may apply in low-risk situations, such as government entities, public institutions, long-standing, well-known clients with transparent ownership. Even in these cases, simplified client due diligence must be documented and justified. Enhanced due diligence is required in higher-risk scenarios, including politically exposed persons, complex ownership structures, cross-border transactions involving high-risk jurisdictions, and unusual or unexplained sources of funds. Enhanced due diligence measures include additional identity verification, verification of the source of funds and wealth, senior-level approval within the firm, and ongoing monitoring.
A beneficial owner is the natural person who ultimately owns or controls a client or exercises effective control over a transaction. Legal practitioners must look beyond registered shareholders or trustees, identify individuals with controlling interest or influence, refuse instructions where beneficial ownership cannot be reasonably established. Failure to identify beneficial ownership is a key vulnerability highlighted in Nigerian risk assessments. Politically exposed persons are individuals who hold or have held prominent public functions, including senior government officials, judges, military and security chiefs, and senior executives of state-owned enterprises. Where a client or beneficial owner is a politically exposed person, enhanced due diligence is mandatory. Source of wealth must be verified. Ongoing monitoring is required. A politically exposed person status alone does not prohibit representation but elevates risk. CDD is not a one-off exercise. Lawyers must monitor transactions throughout the client relationship, update records where circumstances change, reassess risk where new information emerges. Suspicious patterns may include sudden changes in transaction size, inconsistent funding sources, pressure to avoid documentation. Legal practitioners must maintain CDD records for at least 5 years after the end of the client relationship. Ensure records are secure and confidential, and make records available to the NBAAMLC upon lawful request. Client confidentiality does not prevent CDD. Under Nigerian law, confidentiality does not extend to facilitating illegality. CDD information is collected for professional compliance. Disclosure is limited and routed through NBA-approved mechanisms. The RPC carefully balances confidentiality with public interest. Thank you for completing Module 5. You now understand the vital role of client due diligence in legal practice. Apply these principles to protect your firm, uphold ethical standards, and contribute to the fight against financial crimes.